Welcome to Case by Case. This is a podcast brought to you by Calum Chain and Luke Sadkovich of ZFZ. Hello, Calum. How are you today?
I'm very good. How are you doing, Luke?
I'm very well. Very well. This is a good one. This case today. I'm looking forward to getting into it. Thank you, everyone, for joining us today. We hope you enjoy this episode and have been enjoying our others in the Case by Case series. If you happen to be joining us for the first time today, where have you been? No. What we do is we each, Calum and I, we read a legal case. Could be on any topic. Tend to focus on commercial law, but we've got all sorts of things in the back catalogue, and we each read it, jump on the recording and hit record, and then we talk about it. Haven't shared any notes beforehand or anything like that, so it's usually a pretty flowing conversation. One cut, we don't go back and edit it, other than maybe cutting out a few ums and ahs here and there. But what you hear is the conversation that we organically have on the case, and hope you enjoy this. With that, Calum, should we get into this one?
Let's jump right into it, because it's interesting. You know, the way that we do this is we pick cases that are current almost always, if possible within the last few weeks, but normally within at least the last year or so. And because of that, you see the flow through of different issues before the court, and it's quite an interesting way of just picking up these kind of legal points and the principles of law as they get reiterated time and time again through the court process. And this is quite a good example of that, because it's old law being reapplied in a new context. It's probably one of those cases I put it in the refresher case bucket rather than the new law bucket.
I like that. And yeah, for me, it also takes you back down memory lane a little bit. And I'll tell you why as we get into it. But if you enjoy this, if you're enjoying the series, please do follow us, subscribe to the podcast, where it's on Spotify, Apple, Google, or YouTube, which is a new thing for us, having these podcasts on video. A little bit daunting, so it's not just our voice, but now it's also our visual too. So still getting used to that. Not as much like kind of scurrying around on the screen and having to look straight and all these things, all these tricks of the trade we've got to learn, Calum, huh?
Exactly, a new thing to learn. So excuse us if in the first few episodes we're not quite as polished on the video.
Exactly. Good stuff. Well, let's introduce the case. The case today is called Lenkor Energy Trading and Irfan Iqbal Puri. This is another commercial court case in England. Neutral citation is 2022 EWHC 2113 Comm. As Calum mentioned, its recent case handed down on the 9th of August 2022. And this was Mr. Christopher Hancock, QC, sitting as a judge of the High Court. The case is about an exception in a worldwide freezing order. This exception is known as the Angel Bell exception. It's the exception that allows a party, notwithstanding a freezing injunction against them, to continue to use their assets in the usual course of business. It's one of two main exceptions. There are other parts to a freezing injunction we'll get into. There's another one that allows a party to use their assets to fund the legal costs in defending their position with respect to the WFO. And it's on that other exception that I had a really interesting case. And I'm not sure if I told you about this one, Carl, and I'll keep it really short, otherwise I could spend the whole podcast talking about that one, where we were on for the defendant and the claimant. It was a reported decision, Cardigan and Tolley and others, where the claimant had managed to get a proprietary injunction as a part of a freezing order over monies that were sitting outside of Russia. The money sitting outside of Russia weren't worth all that much. And there was an exception in that freezing order that allowed the defendant to continue to spend their money on legal costs. I think it was about 2 or 3 million sitting outside of Russia. And it was the underlying facts had to do with secret commissions. And the claimant had originally managed to get a proprietary injunction over those monies sitting out on the basis that these secret commissions, or alleged secret commissions, belonged to the company, because the commissions paid to one of the directors. And we challenged it on the basis of that there wasn't a proprietary injunction. That also succeeded. And what that practically meant, because of the other exception, the legal cost exception, that the defendant could continue to spend the money sitting outside of Russia in defending their position with respect to the overall proceedings, which would have easily been ruled at 2 or 3. And it led to the whole case kind of collapsing, if I can say that. It was a fascinating case. And I had thought, this is many years ago now, I had wondered at the time about the nature of the exception and what might have been done to challenge that. As I say, that was the exception to pay legal costs. This is the one for course of business. But what's really interesting about these cases is there are kind of tactics, if you like, or there are issues that kind of inform the way that the strategy plays out in the underlying proceedings, or what's going to happen after the event, after the order is in, the freezing order is in place, that informs how strong the injunction is in the first place. And that is also when put against the asset position of the party that you've got the order against. Yeah. I just wanted to say that at the outset, there's a little bit of kind of context, because I find freezing injunctions fascinating. We have a lot of experience dealing with them. And this case has a really important point in it, I think, which we'll get into in a minute.
Yeah, and I think particularly as in this case, where you're looking at a freezing injunction obtained off the back of a judgment. So you're really looking at enforcement here. This isn't a situation necessarily where, you anticipate having a claim and you're then bringing that application for a freezing order to try and secure the future claim. This is one where you have a judgment, and the question really before the court here is, in those circumstances, and in the particular circumstances of this case, is it right for there to be this exclusion where the unsuccessful defendant, the person who has a judgment entered against them, is able to continue trading effectively?
Yeah, and exactly. And what's interesting about this case is that this Angel Bell exception had been challenged previously before there was a judgment. So it actually was even before Mr. Hancock QC. It came before him, a year or two before, where there was a judgment, right?
Yeah, or at least there wasn't an English judgment. There was, correct. By that point, there was a judgment in Dubai. So I guess the backgrounds to this is very briefly given in the judgment, and I actually don't think it's hugely necessary for the purposes of the discussion, save for a few points. But basically, there was a transaction behind the scenes, and as part of that transaction, there were two checks that were drawn in favor of the claimant, and the money behind those checks was basically spirited away somewhere where it shouldn't have been, and that there was never really a good answer provided for why that happened. But that led them to go through a claim in Dubai, ultimately leading to a judgment in the Dubai courts of somewhere in the region of £26 million, £26 million. And they then moved to have that judgment recognized in the English courts. And at the same time, they applied for a worldwide freezer, which at the very start, this is back in 2019, they applied for a worldwide freezer and it was dismissed. That part of the application was dismissed. They got the freezing order, but what they did not get was this exclusion of the Angel Bell exclusion. So they had a freezing order, but the defendant was still able to continue using their assets to trade. And what then happened was the claimant went through the English courts, effectively going all the way through the English courts until they had a final and unappealable judgment. And with that final and unappealable judgment then secured a few years down the line, they then reapplied and asked the court to exercise its discretion to alter the terms of the worldwide freezing order to remove this angel bell exception. And that's the judgment that was before us, or before the court, and the one that we're discussing today.
Yeah, and it's really interesting to see. There were two stages, two moments in time when the sitting judge looked at the same application to remove the angel bell exception. One before an English judgment was in place, and one after, post-judgment.
Yeah.
And it's a really important distinction, because the judge found on the first occasion that it was brought prematurely, and it was too early to lift the exception, deny the exception. But on the second occasion, post-judgment, when weighing up the various factors, and there's a discretion involved here, when the judge used his discretion on the second occasion, spoiler alert, but he decided to lift the exception. And so the defendant was not able to continue to use his assets to trade without first dealing with the freezing injunction. And we'll get into a bit of law on that, and also what were the factors that influenced the judge to come to this decision post-judgment, where he didn't come to it pre-judgment. And one of the first factors on that is the very fact that there is a judgment in place, and we're looking at something post-judgment. But do you want to touch on the law for a moment, Calum?
Yeah, I think we should. That's where I was going to go on, because it's set out in this judgment well, and it's also I think quite authoritative, and it's quite well settled law. So when you're looking at this situation as you have here, where there is now a judgment in favor of the claimant who has the benefit of the worldwide freezing order, the case that you look for guidance on whether or not the angel bell exception should be upheld is the case of Emmett and Wilson, which is a case from 2019 in the Court of Appeal, and it was Lord Justice Gross giving the judgment in that case, and the court there drew kind of 5 principles, although 2 of them are quite closely aligned, that are the key factors that should be taken into account when you're making this decision to, not to have the angel bell exclusion. So the first is just noting that the nature of a post-judgment worldwide freezing order. And in the Court of Appeal, in that case, they said that it's not a rare thing to have. They said that it doesn't confer some kind of preference to other creditors. That's not the nature of a freezing order, and it shouldn't be seen as something that has that effect, because it doesn't. And the reason that you would have one of these injunctions is that without it, you would have a difficulty executing the judgment. So that was kind of the first part of this of the judgment they referred to. The first thing they did was really look into what is one of these post-judgment worldwide freezing orders. The second point they mentioned is that there's nothing illegitimate about getting a worldwide freezing order in that context. It does apply pressure on the other side. The court accepts the reality there that having one of these worldwide freezing orders does effectively put the other side under serious pressure, but it doesn't go as far as doing anything illegitimate. So it's not something that would be disallowed because you're trying to do it for illegitimate reasons. The third and fourth are both quite closely aligned, and this is basically talking about whether it's appropriate or not to remove the angel bell exception. And the court kind of between these 2 principles comes down saying that it's on the scale of likelihood of it being appropriate. It falls somewhere between sometimes and usually it would be inappropriate to include the exception.
Perhaps usually,
yeah.
And we're both smiling as Calum's reading that out, because that language is repeated at least 2 or 3 times elsewhere in the judgment by the sitting judge, and I like it. I think it kind of, in a way, it kind of frames the application of the discretion, right? It really sits there as the foundation from which the judge then goes on to weigh out the various factors.
Exactly.
And exercise his discretion.
And I think it's probably part of a lawyer's role is often advising on the likelihood of a specific outcome. and it's something that lawyers do a lot. So I always find it quite interesting when people try and put words or numbers onto the particular likelihood of an event happening. And if you have this full spectrum from certainly not happening to certainly happening, I like the chance of this exception being inappropriate is the chance of this exception being inappropriate is somewhere between sometimes and perhaps usually. So on that spectrum, I don't really know where that puts us, but
I think that's another phrase to stick into the toolbox, isn't it? Along with likely, probably, possibly,
exactly.
more likely than not. We've got a whole bunch of these kinds of phrases we use. But what it means, I think, just cutting through it, and this is often our role, isn't it, as legal advisors, is to strip it back and say, what does this mean? What this means is if you have a judgment against a party where they've got a worldwide freezing order against them, it's going to be the defendant, the party who has that judgment against them and the freezer against them, to have to convince the court that there are pretty good reasons why they should be able to just continue going about their business, trading, and ignoring the freezer and the judgment.
Yep.
More importantly, ignoring the judgment, and that's the starting point. And it's an uphill battle for the defendant thereafter. Is my takeaway, and really kind of the overarching remark I've got about this decision. Now it gets into more detail than that, but that. It's this phrase from an anomalous decision which really sets that up.
I agree, and I think the court tries not to put it quite that strongly, and they say it doesn't go as far as becoming a starting point for the discussion. But really, reading this case and reading between the lines, I think it probably is as close to a starting point as you can get without actually being this is the departure point. You're certainly on the back foot if you've got a freezing order against you and a judgment against you to try and persuade a court that you should be entitled to continue to trade in the meantime.
Yeah, look, to be clear, from formally speaking, each case will turn on its own facts, and it's an application of discretion. And the phrase that we've read is the principle, but it just, I'm talking more from a practicality.
Yeah, exactly.
It's a difficult position to be in, and in cases, as we know, to get worldwide freezing orders, there's already been a showing of risk of dissipation of assets. There's often elements of wrongdoing. We're now talking about a situation where there's a judgment on top of the freezer, so it's post-judgment. And the defendant's wanting to say, well, I want to be able to continue to trade. So, stacking all those things up, you can, I suppose that's where I'm coming from.
Yeah, I totally agree with that. So then I think let's just look at it in the context of what happened here, because it's quite an interesting case study. And as I kind of alluded to at the start, the facts aren't hugely clear in what happened in this judgment, nor do they need to be, save to say that there was some behavior that seemed a little bit shady. And firstly, there was, as you can tell, there has been this judgment outstanding against the defendant for a long time, this judgment in Dubai, without any effort to satisfy that judgment. So it's having to be recognized in the UK courts. It's going through the UK court process, and there's no attempt to satisfy the original Dubai judgment. There was no attempt to account for what had happened to the sums that had been misappropriated in the original fact pattern that gave rise to the dispute in Dubai. Not even to really explain why that had happened. There'd not really been any sensible explanation for that. There was an alleged history of dishonesty, and that was quite an interesting one, because the judge, I say judge, it was Christopher Hancock QC sitting as deputy, but his view on the dishonesty was quite interesting. And he effectively, what had happened was there was an allegation of dishonesty, and the other side had refused to answer it. And instead, the other side had accused the person making the allegation of dishonesty. They'd said, well, actually, you're being dishonest. So he had a bit of a he said, she said. And the judge said, well, actually, the fact that you're alleging the person who made the original allegation of dishonesty themselves doesn't do anything to dissuade me from thinking that you've been dishonest. And equally, not answering questions about your alleged dishonesty isn't evidence that you are not dishonest. It's just a failure to try and disprove the allegation of dishonesty. So he didn't come as far as saying, I find that they were dishonest, but you could see that it colored his judgment, because he could, there was just nothing for him to go with from the defendant in trying to disprove any dishonesty.
Yeah, exactly.
Yeah. And then they also had a few other things. They looked at the history of assets being shifted around. They looked at a breach of the original worldwide freezing order, and they looked at some evasiveness towards service.
So for the defendant, if I may take the other side of this,
please do.
Valiantly.
The harder side. It's very generous of you to take that
let's
side.
just say the harder side. Yeah. Well, look, the defendant was arguing that the effect of removing the exception would mean that the claimant would become a preferential or secured creditor. That somehow they would be bumped up the priority chain in terms of the creditors that the defendant had, and that it's tried to say that a freezer is not intended to give a claimant a proprietary or preferential interest in the assets of the defendant. And the argument was that would be draconian. That was one point that was made. Another point, sorry.
Maybe stop on that one, because I think it's an interesting argument. Because the practical effect is surely that the next thing that company has to do to even have a hope of surviving is make payment of the judgment. So does that end up being I don't know, is that, I would need to refresh my memory of insolvency law, but is there a danger there that payment is a payment made in preference to other creditors? You can see why that argument was run. It's not, it's not the worst point, really. The practical effect of this is to cut across any other creditors who may otherwise have been paid in the ordinary run of business.
Well, that's because, so the argument goes that because the freezer in place, and to lift the freezer of this judgment would need to be satisfied or paid, or security posted, I suppose, to get the freezer out of place, that practically speaking, that means that this judgment has to be dealt with before any other judgments that don't have the backing of a freezer.
Yeah.
And it kind of gives some elevated status to this position. I suppose that's only because of the combination, isn't it, of a judgment and a freezer. If there had been something before, like if there had been a judgment of someone else that they wished to pay prior to this judgment, this English judgment being rendered, then they could have paid that, right? That would have been part of the ordinary course of business. So it is only the combination of both of those that kind of brings it to have that more urgent status.
Well, exactly, and I think that that's a really important point for this, for when you're thinking about, can you remove this angel bell exception? Because obviously, if you can have a freezer without that exception, then it's an immensely powerful tool, because effectively you're saying this company cannot do anything until we're paid. And I think that's the reason why it's much harder to get a freezer without an angel bell exception prior to any judgment, because you are essentially throttling them from doing anything. But after judgment, the court says, no, you owe them this money. You owe them it now. You've got to pay it.
Yeah, exactly. And if that puts them into an insolvency situation, they're going to have to deal with these issues in the context of an insolvency action. And that's really the effect, right? The courts, in a way, say, well, okay, if this is going to tip the defendant over into bankruptcy, insolvency, then that's where it's going to head, and it should have been dealt with before. Yeah. So anyway, that was one of the arguments that was made. The second one was that the defendant doesn't have sufficient assets to satisfy the judgment. It was argued, it wasn't accepted, but it was argued that there was no material change of circumstances other than obtaining the English judgment since the application was refused in 2019, and that absent any change of circumstances, there's no reason why the court should come to a different conclusion than was reached in 2019. The fourth argument was that the claimant did not seek to have the exception removed at any time up until the refusal of permission to appeal by the Supreme Court. And there are a couple of other points made there. I don't think we need to get into them in too much detail unless there's anything jumping out at you.
No, but there's the last two that you said, they kind of come together to where, the defendant was saying there's not really been any, firstly, there's not been any change in circumstance. And secondly, why are you only bringing this now? And those are, well, they were obviously trying what they could, but that's not a great argument because obviously there is the massive change in circumstances, which is that there's now a final unappealable decision against them in the English courts. So it's hard to overlook that one. And also, they said you didn't seek to remove this exception at any time until the Supreme Court refused permission to appeal. Well, I think the answer to that is quite naturally, that was the point at which we had a final unappealable decision. And that was the change of circumstances, which now leads us to ask the court to re-exercise its judgment for its discretion, for which the court decided to do. There's a point there, which is that, where the court has exercised discretion in one way, in a case which is continuing on a point of discretion on certain facts, there is that point at which it's open to a party to ask the court to exercise its discretion again because something has changed. And that's what you have here, really. They're not bound by that 2019 decision. They're saying in 2019 circumstances were different. We come back to the court. We say we're going to ask you to exercise the same discretion we already asked, but we're asking you to exercise that discretion now in the light of the new situation.
Yeah, it's a really important point to keep in mind with freezing injunctions, because often freezing injunctions are obtained in circumstances of urgency where you're turning up to court and you're saying, look, if you're the claimant, the other party is trying to dissipate some of their assets. You move ex parte, you ask the court, say, look, we'll show you the risk of dissipation. We'll also show you some wrongdoing, and you get the freezer. You then serve it on the other side. And in some ways, the court puts the freezer in place to maintain the status quo, or seek to maintain the status quo, until it can hear from the other side. And the other side comes back. And first thing they have to do is give disclosure of their asset position. They may then come and challenge the freezer. They may challenge parts of the freezer. They may ask for exceptions to the freezer, like the Angel Bell exception. And because of the very nature of the freezer just intending to stop the dissipation of assets, it is an ongoing situation, right? So you've got ongoing litigation underneath, still or some action somewhere, arbitration or something. You've got the freezer. You've got a party wanting to continue to do business. You've got a party wanting to continue to pay legal sums. They've got their assets under some hold. Their asset position could be changing. You've got other creditors probably coming into the mix. It's a fluid situation. So in cases like this, I think you're so on the money to be identifying and emphasizing that you need to be thinking along the way of what can we do now that we might not have been able to do on day one to challenge the freezer? What might we be able to do now down the track to buttress the order that we couldn't have done on day one? And that's what we've seen play out here. Here, it was really the step of let's get an English judgment. Once we get an English judgment, then that's going to allow us to lift the Angel Bell exception, and that's going to really change the dynamic of this whole situation.
And I think actually, you made the point there that the pre judgment freezing order is all about holding the ring. And that's why you have to have that process of finding out what assets people have and monitoring those assets, etc., through the process of having the freezer. And that's probably the nub of this case, is that before you have a judgment, it's all about holding the ring. But once you have a judgment, holding the ring is actually not that helpful anymore, because you're not trying to hold the ring anymore. You're trying to execute a judgment in favor of the successful party. So there's a fundamental shift in the way the freezer is used, and I think that's quite a neat way of summarizing why this Angel Bell exclusion was lifted.
Yeah, exactly. Yeah, and so ultimately the judge came back, exercised his discretion, started from the Emmett and Wilson and Nomerhold principles. That's where the quote, as we talked about before, it will sometimes and perhaps usually be inappropriate to include such an exception in a post-judgment worldwide freezer order. He then looked at the policy of the law, which had been noted by the Court of Appeal in Emmett and Wilson, to strongly favour the enforcement of judgments. And that's really a critical part to this whole decision, is that with the judgment in place, the court wants to see judgments satisfied.
Yeah.
So that was a strong factor, a way of the sitting judge's mind. In terms of the facts of this particular case, there'd been a complete dearth of evidence, really, as to what the nature of the defendant's business was. What was he spending his money on? What was the profit and loss looking like? Was it a thriving business? Was it a struggling business? There wasn't enough evidence on that, and the defendant wasn't really forthcoming.
And it's that's quite an interesting point, because the defendant has to be forthcoming to say, this is how the money's going to be going in and out of the account. And the judge is saying, well, it's one thing for us to just have the exception in that says you can keep using the money in the ordinary way for your business. But what is the ordinary way for your business to use this money?
Exactly.
Exactly. It's not, you've not shown us. So, yeah. So the sitting judge made the point that it's really incumbent on the party who's seeking to justify having that exception in place to explain how it's impacting the business, right? And how the removal may hurt it. There was another factor. This is another factual factor where the judge said it's of great importance that the defendant had given no explanation of what happened to the actual money, that he or his company had misappropriated. Didn't like at all the suggestion of, well, I'm the individual and this is something that the company did, and there's some distinction there, which the judges thought was completely illusory. And there are some allegations of dishonesty and wanted probity, which the defendant hasn't really provided a good answer for. So it was this combination of factors, really. It was, and you could see how, if you were trying to satisfy the judge to maintain this exception, if you were, and this, I'm sure this was attempted to be done by those representing the defendant here, but you can see in other cases, right? Hypothetically, with this list of factors, that weigh by a judge in looking at the discretion, how you could try to bolster the case for the defendant. You can say, look, let's explain what's happening with your business. Let's show what money you need to spend on an ongoing basis to stay alive. That where you can continue to make some money so you can actually cobble together the funds to then pay the judgment. Maybe there's a way of partially satisfying this, lifting the exception, or allowing you to continue to incur a certain threshold of money. But that would require disclosure. You'd also have to say, look, there are these allegations of dishonesty. What's our explanation? Now, I'm not saying that there are any good answers to any of those points in this case, but it's a really useful checklist to work your way through if you were trying to maintain this type of exception. It is, and I think cutting across it, what had really happened here in this whole situation is that some money had been misappropriated, and there's then a very, very long process in a couple of jurisdictions at least of putting the defendant into a position where they have this judgment that is enforced against them, and they're just very slowly closing that circle bit by bit. And you can see that with the Dubai judgment, and then they get the freezer, and then they get the judgments in England all the way through to, which are contested and appealed and contested and appealed until you get to the Supreme Court, and they say, no, we're not going to take the appeal. Then they come back to remove the angel bell exception in the freezing order. They're just bit by bit kind of like ratcheting the pressure up on the defendant to say, pay us. And, who knows if they're ultimately going to get paid. It's often easier said than done. And I dare say there may be more procedural fun and games, but the claimant is now, in a in a strong position. They've got a worldwide freezer, and there's nothing that can be done other than being in breach of that freezer to use any of the assets in the company. So they're in a strong position.
Yeah, exactly. Well, look, I enjoyed skipping through that case. I hope everyone listening has found that useful. Freezing injunctions are, they're a fascinating area of the law. They can be draconian in some ways. The nuclear, the thing that they refer to as the nuclear weapon of of the English procedural law. If you've got any questions on this type of area, please get in touch. We like talking about these cases. If you're wondering how it could have been different, or how the other exception may be viewed in this kind of scenario, please do let us know. Hopefully that's been of some use. And any last remarks from you, Calum?
Nothing from me. Like just enjoy your week. To all our listeners, thanks for listening in.
See you next Thursday. Thank you, everyone. Bye.
Cheers.